From the start in this country, black people were treated differently in our laws. The Constitution said the black people in southern states, the slaves, should each count as 3/5 of a person in the census. Then, when the slaves were freed, the country did not exactly welcome them into the voting booths. They were subject to all manner of discrimination and attack, including murder, for simply attempting to register to vote, never mind actually voting. Something had to be done, but it took the country 100 years to do it. And in 1965, President Lyndon Johnson signed the Voting Rights Act into law. It said essentially that in the parts of the country where discrimination against black voters was the most extreme, the federal government would have oversight authority for any changes made in voting procedures in those areas. The worst offenders being Alabama, Georgia, Louisiana, Mississippi, South Carolina, Virginia, and parts of North Carolina and Arizona. The so-called coverage formula in Section 4 of the Voting Rights Act was based on where the worst discrimination was occurring at that time. It is that section that was ruled unconstitutional today by a majority of the Supreme Court, even though the Voting Rights Act had been renewed by Congress several times since 1965, including as recently as 2006 by a Republican-controlled House and a Republican-controlled Senate, and then signed by Republican President George W. Bush. Chief Justice John Roberts' majority Supreme Court opinion believes that the Republican Congress and that Republican president did not know what they were doing. If Congress had started from scratch in 2006, it plainly could not have enacted the present coverage formula. It would have been irrational for Congress to distinguish between states in such a fundamental way based on 40-year-old data when today's statistics tell an entirely different story. And it would have been irrational to base coverage on the use of voting tests 40 years ago when such tests have been illegal since that time, but that is exactly what Congress has done. Attorney General Eric Holder had this reaction.
I am deeply disappointed with the court's decision in this matter. This decision represents a serious setback for voting rights and has the potential to negatively affect millions of Americans across the country. Congress needs to act to make sure that every American has equal access to the polls. The department also will work with Congress and other elected and community leaders to formulate potential legislative proposals to address voting rights discrimination. Because on their own, existing statutes cannot totally fill the void left by today's Supreme Court ruling. And I am hopeful that new protections can and will pass in this session of Congress. The Voting Rights Act has always had strong bipartisan support on Capitol Hill, and today's ruling should not change that.
Joining me now are MSNBC's Melissa Harris Perry and SCOTUS Blog's Amy Howe. Amy Howe, the court surprised me today when it decided that the formulas that Congress was using in legislation in 2006 were simply too old to be used in legislation in 2006. You have farm legislation that uses formulas from the 1930s. You have Medicaid legislation that repeatedly uses formulas that have been set for decades. And one of the reasons for that is the political negotiation of changing those formulas actually has a sort of quicksand in it. And so I'm not aware, are you aware of any previous case where the court simply said your political process at arriving at this formula is something that we just don't think is workable based on the dates of the information you're using?
Well, I don't know that there's any case that says that. What the Supreme Court said was that back when Congress passed the Voting Rights Act in 1965, the voting discrimination going on in the South and some other places was so pervasive that the kinds of burdens that the Voting Rights Act imposes were justified. But it said if Congress is going to impose those burdens today, it needs to make sure that the burdens reflect the current needs. And it said Congress can't use 40-year-old data to do that.
But Melissa, the Congress that voted to impose this included votes from the members of Congress that represent those areas where the so-called burden is imposed.
That's right. And I think we have to be very careful here, because for folks who aren't constitutional scholars or don't follow the Voting Rights Act, when we say language like burden, even though I recognize it's a legal term, it sounds as though there's some sort of penalty attached to being part of a preclearance state, that there's some sort of federal law that comes in. And that's not right. That's not accurate. What preclearance did was to put the burden on states that had a sorry record of democratic action. In other words, rather than acting towards the expansion of democracy, these are jurisdictions that had consistently worked to restrict democracy. And as a result, they had to demonstrate that any rule change that they wanted to bring had to, in fact, meet this test, a test that, in fact, the rule would not again, restrict democracy. And we have in our Constitution, in the 14th Amendment, a very clear example of saying that states that have a sorry record have to reach a higher standard. And that is, of course, that after the Civil War, you didn't just get to come back into the Union. You had very specific rules that had to be followed in order to have full sort of states' rights back in the Union again. And it's because of what they had done under the context of the Civil War. The same thing is true here. It is fully constitutional to treat states differently based on their behavior.
Justice Ginsburg, in her dissent today, said the court's opinion can hardly be described as an exemplar of restrained and moderate decision-making. Quite the opposite. Hubris is a fit word for today's demolition of the Voting Rights Act. Amy, this is the majority of this court, these Republican appointees, claim to be not activist judges, to let law stand where written by Congress whenever possible. This reach into a formula used in the internal calculation of a law does seem to me to be real judicial activism.
I think both sides tend to define activism as a decision that you disagree with. What the majority said was that they felt like they gave Congress a warning shot back in 2009 when it decided another case involving a similar issue. And in that case, they said, current burdens have to be justified by current needs. And they felt like they'd given Congress a chance to solve the problem. What they saw as the problem, Congress didn't take them up on the opportunity, and they said, we have no choice other than to act.
And Melissa, it's, I suppose, conceivable that it could be worse. Certainly, Justice Thomas indicates that he would like to get rid of the whole thing.
Yeah, of course it could be worse. I mean, it's so ugly about both this decision and the action decision. In both cases, what this court does is a kind of bullying move, where what they do is to actually gut or signal quite clearly what their preferences are, but then they're also sort of so cowardly that they actually punt it back. So at this point, what we have is a punt to Congress that says, if you can come up with a formula that we find acceptable, then in fact the fourth section of the Voting Rights Act could give teeth back again to the fifth section of the Voting Rights Act, which of course was not actually touched here. Of course, the problem is that the justices are pretty notoriously hard. And this is true not just these justices, but sort of, far back. They are lovely in terms of their understanding of the law, but when it comes to understanding how social sciences work, they actually generally don't rely on these sorts of claims. When they often do so in ways that are specious, that just allow them to make the ideological claims that they want to make. And so to send back to the 113th to now make a new coverage formula is, I think, actually sort of frustratingly problematic in terms of their willingness to punt on this issue.
And Amy, if the Congress actually did take this up and they sent back to the Supreme Court, they actually then again voted on exactly the same formula and sent it back, would the Supreme Court then claim again they didn't know what they were voting on?
It's hard to say. That they would want to look at the record that Congress created. I think one of the things that frustrated the majority was that it felt like Congress had arrived at its conclusion that it was going to renew the Voting Rights Act before it actually compiled the record. They would certainly take a good hard look at it, but if there were enough findings in the record, it would depend a lot on the particular challenges, which I'm sure would wind up in court quite quickly.
Well, Melissa, they had a large number of hearings before this last reauthorization in 2006. This legislation had as much premeditation as you could find in virtually any legislation that moves through there. And Congress made its decision and cast its votes.
There was absolutely a mountain of data. And also, even by, I mean, you know, our standards now of what counts as bipartisan is one or two members from the other side, you know, managing to come over. These were truly bipartisan votes, nearly basically unanimous in the Senate, nearly unanimous in the House of Representatives, after a mountain of data that was presented about not only historic wrongs, but ongoing attempts. And look, if anyone needs sort of, you know, just a clear recognition of what these states look like, all the one would need to do is to look at what happened in the 2012 election cycle. Now, there is an argument to be made that many states that were not covered under preclearance were actually some of the most egregious violators. But the notion that part of what happened in the Voting Rights Act, and particularly in preclearance, was to stop the sorts of things that we saw go on in states that were not covered is an argument for extending it, not for restricting it.
Melissa Harris Perry and Amy Howe, thank you both for joining us tonight.